Hi, so if you're watching this video, it means that you're interested in learning more about immigration options for people that have an employer in the United States willing to sponsor them, willing to file a petition on their behalf for either a green card or for some other type of work visa. So that's wonderful because in this video, I'm going to discuss multiple ways that someone can get immigration benefits to the United States based on having a job offer from a U.S. employer. So let's get started. As a quick introduction, my name is Michael Ashoori and I'm a U.S. immigration lawyer based in Los Angeles, California. At my law firm, we work with clients from all 50 states and worldwide. So let's get started. So the first immigration option that I want to talk about is an employer-sponsored green card. So if you don't know, you could potentially qualify for a green card based on having a full-time job offer from a U.S. employer that's willing to sponsor you and petition you for your green card. And I'm going to give you a big picture overview about how this process works. So basically, the process is broken down into 3 separate steps. The first step is called the PERM labor certification process. The second step is filing the immigrant petition. And the third step is to either do an adjustment of status if someone's lawfully present in the United States or to apply for their immigrant visa. Now, again, this is going to be a big picture overview about how this process works. So basically, as we discussed, the first part of the process is referred to as the PERM labor certification process. And basically, during this process, what the U.S. employer has to do is they have to show that they have a position available within their company, a full-time permanent position, and they have to show that they tried to hire a U.S. worker for the position and they were unable to find and secure a qualified U.S. worker for the position. So now they are filing an application with the Department of Labor to get approval to be able to hire a foreign worker for the position. Again, this is part 1, the PERM labor certification process. And basically, the employer has to do multiple things. The employer has to post job ads in various platforms and conduct recruitment to hire a U.S. worker. The employer also has to identify the prevailing wage. The prevailing wage basically is the amount that a similarly situated U.S. worker would get paid for the position. So basically, in our immigration laws, the government doesn't want to allow a situation where foreign workers, non-U.S. workers, can come to the U.S. and work for less than what a U.S. worker would make. So the immigration rules, the immigration laws require that foreign worker that's getting sponsored must get paid the same amount, at least the same amount, as what a similarly qualified U.S. worker would get paid for that position. So the U.S. employer has to find out what the prevailing wage is. What is that amount that a U.S. worker would get paid for the position? And they must offer at least that amount to the foreign worker. Additionally, the U.S. employer must show that they have the means to pay that amount. So they must either show a bank statement showing they at least have the amount needed to pay that foreign worker's salary, or perhaps they can show tax returns demonstrating that they had that amount in profit. But the U.S. employer basically must demonstrate that they have the financial means, the financial capacity to pay the amount that the foreign worker would get paid. And again, after they go through this recruitment process and they show that they were unable to find a qualified U.S. worker for the position, then they file the PERM application to get approval from the Department of Labor to be able to sponsor a foreign worker. So once the PERM application is approved, then we move to step 2, which is to file the immigrant petition. The immigrant petition is the form I-140 and it's filed by the employer to USCIS. During this part of the process, we identify the foreign worker that the U.S. company is seeking to sponsor, and we demonstrate that that foreign worker satisfies the requirements of the job and that they meet the various educational requirements and professional experience requirements that were required from the employer for this position. And again, this is part 2, the immigrant petition. So part 3 of the process is either doing an adjustment of status for somebody that's lawfully present in the United States, or to do consular processing, immigrant visa processing, for those that are outside of the United States. So what is an adjustment of status? It's basically for somebody that's in the United States in some sort of a non-immigrant status. For example, if somebody's in the United States under an H1B visa or some other type of non-immigrant status, the adjustment of status is where you go from that non-immigrant status to lawful permanent resident status. You're adjusting from non-immigrant status to lawful permanent residence. And again, that's done by filing an adjustment of status. And in order to do this, you must have a visa number available, your priority date must be current, and you must be lawfully present in the United States. Now, for those that are outside of the United States, they would likely do immigrant visa processing, also referred to as consular processing. And this is where they would essentially apply for their immigrant visa at a consulate abroad. At the appropriate time, they would go for their visa interview, and upon successful completion of their visa interview, they would get their immigrant visa stamped in their passport, which would allow them to come to the United States. Now, a couple of important points regarding steps 2 and 3. Now, in some cases, if somebody's priority date is current, which means that an immigrant visa is currently available, they can file steps 2 and 3 concurrently. And in other cases, depending on somebody's country of birth and depending on the visa bulletin, they might have to wait years and years and years before they can complete step 3 of the process. Now, I know this is a lot of information and I know it can get a little bit confusing, but basically what I want you to know is that the big picture way that a US employer can sponsor a foreign worker for a green card is by giving them a full-time job offer. Again, as we discussed, the US employer would have to show that they tried to get a qualified US worker. They were unable to find a qualified US worker, so they got authorization from the Department of Labor to sponsor a foreign worker with a job offer. Once that process gets approved, then you file the immigrant petition and either do an adjustment of status or immigrant visa processing. And again, that's a big picture overview of how the employer-sponsored green card process works. Now, for people that were born in certain countries, the process can be as short as 1.5 years. And for others that were born in other countries like India and China, the process can take years and years and years because of the shortage of visa numbers. So now that we talked about the employer-sponsored green card, let's move on to some non-immigrant visa options, some other work visas that somebody could potentially qualify for to be able to live in the United States and work in the United States. So first, let's talk about the H1B visa. H1B visa is one of the most common work visas in the US. What the H1B visa allows is it allows a US company to sponsor a foreign worker to work in the United States in a specialty occupation. In order to qualify as a specialty occupation, the job must require some degree of specialized knowledge, and generally speaking, a bachelor's degree should typically be required to work in that occupation. And basically, the H1B visa allows a US employer to sponsor a foreign worker to work in the United States in a specialty occupation. The next work visa that I want to talk to you about is the TN visa. Now, the TN visa is specifically for citizens of Canada and Mexico. And the way it works is that under the TN visa, there's a list of different types of jobs. For example, you have doctor, dentist, management consultant, and about 60 jobs in total. And in order to qualify for a TN visa, a US employer has to offer you a job in one of these categories. And if you are offered such a job and you have the relevant work experience or professional or educational experience requirements that are required by the TN visa for that particular job, then you could potentially qualify for a TN visa to live in the United States and to work for that employer in that job category. Now, one of the benefits of the TN visa has to do with the level of work that's required by the employer. Now, generally speaking, the different steps that have to be taken by the US employer are less for the TN visa than they are for other types of visas, such as the H1B visa or the employer-sponsored green card. Generally speaking, the employer still has to offer a full-time job and has other steps to take as well. But again, it's generally less burdensome than other types of work visas. Now, another work visa that I want to tell you about is the O1 visa. The O1 visa is a work visa for people that have an extraordinary ability in a particular field. So let's say that you have an extraordinary ability in art or mathematics or sciences or business. Based on having that extraordinary ability, you could potentially qualify for an O1 visa to work for a US employer in the United States. Now you might be wondering, how do you show that you have an extraordinary ability? How does USCIS determine whether or not somebody has an extraordinary ability? Well, the way that it works is that USCIS has various criteria. And in order to demonstrate that you have an extraordinary ability, you have to show that you satisfy at least 3 of these criteria. Now, what are some of the criteria? One criteria is if you've received prizes or awards that are nationally or internationally recognized for excellence in your field. Another criteria is if you're a member of organizations or associations that require outstanding achievement to be a member of that organization or association. Another criteria is if your compensation is high compared to others in your field. Another criteria is if you have material that's been published about you, such as press releases. Another criteria is if you've acted as the judge of the work of others in your particular field. And again, there's multiple different criteria, and in order to qualify for an O1 visa, you have to demonstrate that you satisfy at least 3 of those different criteria. And through the O1 visa, you can work for an employer in the United States. So I want to tell you about another work visa called the L1 visa. The L1 visa is also referred to as the intra-company transferee. And the way this visa works is that it allows a foreign company, so a non-US company, to transfer a certain employee to work for a related US company. In order for this to work, the 2 companies must have some type of a qualifying relationship, such as a parent-subsidiary relationship or an affiliate relationship. And also, in order to qualify, the employee that's coming to work for the US company must have worked for the foreign company for at least 1 year full-time with continuous employment within the last 3 years. And their employment must have been as either a manager, executive, or specialized knowledge worker. So they must have either worked as a manager, an executive, or in some sort of a position which required specialized knowledge. And they must be coming to the United States to either work as a manager, executive, or a worker that requires specialized knowledge. So again, that's a general big picture overview of the L1 visa, and that can also be a tremendous option to allow somebody to work in the United States, again, if the requirements are met. So in this video, we talked about several different options. We talked about the employer-sponsored green card process. We talked about the H1B visa for people that will be working in a specialty occupation. We talked about the TN visa for citizens of Canada and Mexico. We talked about the O1 visa for people that have an extraordinary ability. And we also talked about the L1 visa for people that will be transferring from a foreign company to a related US company. Now, I hope you got a ton of value from this video, and I hope that you learned a lot. But I do want to mention that this video was just intended to provide a general overview. I did not talk about every single detail that has to do with these different options. That would require a way longer video. And my intention behind this video was just to provide you with a general overview. As always, thank you so much for tuning in, and I will see you on the next video.